Hello and welcome everyone. My name is Chris Kay and I'm a research editor at the Legal 500. It is a pleasure to have you all here for our seminar on navigating the EU digital market. This webinar is held in partnership with Gugashev & Partners Law Office to provide an in-depth analysis and overview of Directive 2019/790. Now, as most of you will be aware, this directive is on copyright and related rights in the digital single market and is intended to modernize certain aspects of the legal framework for copyright and neighboring rights, in particular to account for rapid technological developments that are continually transforming how protected works are created, produced, distributed, and used on the emergence of new business models and actors. And to run us through this, I would now like to hand over to Stefan of Gugashev & Partners. Thank you.
Thank you, Chris. Thank you for the opportunity. Thank you for everyone for joining this webinar today. My name is Stefan Kjosef. I'm Business Development at Gugashev & Partners Law Office, and I'll have the pleasure to guide you today to this rather interesting topic that is happening. So, over the last decade, an enormous flow of information has been created since the computing world has invaded our daily lifestyle. The EU, having realized the growing impact of digital and internet technologies, have decided to commit to renewing the single European market, making it suitable for digital age, introducing the concept of single digital market. This is my brief overview of the topic. Today, together with me, our speakers will be Ms. Ioana Ivanova, who is partner and head of IP at Gugashev & Partners Law Office. She's also recognized by Legal 500 as a leading individual. With her, Svetlina Paskova, associate, rising star at our law firm, will also guide us through the topic. Later in the conversation, we'll be joined by speaker Genoveva Petrova. She's a co-founder of Remix Global, which was one of the most successful online platforms in the European Union, selling second-hand clothes. But that's not all of it, Genoveva. She will tell us more about her roads and how did she tackle any legal challenges along the way. Please, whenever you have questions, we will have two panels for questions after the directive and after the regulation, which we can discuss even further topics that might be interesting for you. With that being said, I hope it will be useful for you. This webinar, as you've seen, is recorded and it will later on be uploaded on Legal 500 website. And do not hesitate to get in touch to learn more about this topic, which is currently very new. And we hope that we will just show you the way and navigate you to our first step, which is Directive 2019/790. I will have the pleasure to give the word to Ms. Ioana Ivanova, who will set the stage for this first topic. Ioana, please.
Thank you very much, Stefan. Thank you. Hello, everyone. In 2019, the European Parliament and the Council adopted Directive 2019/790 on copyrights and related rights in the digital single market, which for the purpose of this, we will mention only as CDSM or the directive. The directive was an ambitious piece of legislation supported by multiple rationales, including to guarantee a high level of protection, streamline rights clearance, create a level playing field for the exploitation of protected content, and remedy interpretative uncertainties, and also guarantee a well-functioning and fair marketplace for protected content. On the 7th of June 2021 was, or rather would have been, the deadline for the national transpositions of the CDSM directive. But actually, the CDSM directive is intended to modernize certain aspects of the legal framework for copyright and related rights, in particular to account for rapid technological developments that are continually transforming how protected works are created, produced, distributed, and used, and the emergence of new business models and actors. While the principles in the existing European copyright framework remain sound, the new copyright directive reduces uncertainty for right holders and users with respect to certain usage, including the cross-border use of works and other subject matter in the digital environment. The directive provides for rules to adapt certain exceptions and limitations in copyright and related rights to digital and cross-border environments, and measures to facilitate certain licensing practices. The new copyright directive is advocated by the European Commission, but actually it has received criticism from several member states. For example, from Poland and France, and from Poland, my colleague Svatelina will speak later about in details about a court case and some interesting decisions from this court case. And despite these reserves, the most member states actually have faithfully implemented the directive into their local law, excluding Bulgaria, of course.
Not only.
Not only. And what else is important here? That this new copyright directive introduces some amendments in the legal framework of copyright and related rights. And some of them, the most important, are a new liability regime for the content sharing platforms. From now on, the online content sharing platforms will have to obtain authorization from right holders for the content uploaded on their websites. There are some new exceptions and limitations for authors' rights that apply to reproductions and extractions made by research organizations and cultural heritage institutions, to the reproduction and extraction of lawfully accessible works, and in order to allow the digital use of works and other subject matter for the sole purpose of illustration and teaching. What else? In order to allow cultural heritage institutions to make copies of any works that are permanently in their collections for preservation purposes again. And the possibility for the cultural heritage institutions to use out-of-commerce works subject to the agreement of a non-exclusive license and for non-commercial purposes with a collective management organizations, of course, under certain conditions. Other notable exceptions for which Svatelina will speak about later, but I will just mention some of them in order to know what are the main topics here. Are some changes in the neighboring rights. For example, for press publisher covering online uses of their press publications by the information society service providers. This is important because this will give press publishers a fairer marketplace and stronger bargaining power against online service platforms. What else? The principle of appropriate and proportionate remuneration in an utilization agreements of authors and performers. And if I may give a sum up, and as Stefan said, to set the stage, two things are certain in all of these. The first is that the most EU member states failed to meet the June deadline, which I mentioned at the beginning. Actually, the Netherlands was the first country to transpose the directive in full. However, in a significant number of countries, including Bulgaria, the process is still at a relatively early stage. The second important thing is that compared to when the directive entered into force, today's Europe is a very different place, and it's not only Europe, the whole world, because of the COVID situation, and also because of the Brexit, because of course now the United Kingdom won't transpose the directive. Also, we must know that because of the pandemic and because of the Brexit, there are another important reason for this delay of transposition of the CDSM. And this is the very disputable Article 17. I think it is quite a long piece of legislation.
Yes, page and a
Almost,
half.
yes, page and a half. And Sveti will speak in details about the content of this Article 17, but now the European Commission tried at the beginning of 2019, at the end of 2019 and the beginning of 2020, sorry, to set a kind of a guideline on how this article actually will be implemented and in all the member states. But at the end, this guidance is not actually mandatory, because it is a guidance. It is not a legislation itself.
Yes, it's a soft law.
It's a soft law, yes. And now I will give the word to Sveti to start with the substance and the main idea and the goal of consolidating a digital single market. Sveti?
Thank you, Ivana. So aligning with the goal of consolidating a digital single market, the CDSM directive pursues three specific targets, as announced in its third rates. Though the first one is adapting exception to the digital and cross-border environments, ensuring wider access to content, and achieving a well-functioning marketplace for copyright. The first purpose, as I already said, is adaptive exceptions, another protection of legitimate uses. So the directive influenced a major change in the regime of limitation of copyright from the 2001 directive on the Information Society, also known as the InfoSoc directive, to the 2019 legislative text. Exceptions, at least some of them, have mutated from mere limitation of exclusive rights to proper enabling devices sustaining socially beneficial uses of works and creations. In 2001, the objective was mainly to limit the cases where member states could provide for an exception to the exclusive rights to a narrow and exhaustive list for the sake of harmonization across the EU. The primary concern was then to properly tame uses of works that could benefit from a copyright exception, so as to avoid their spread, which was perceived as a threat to effective copyright protection in the digital environment. Of course, we all should keep in mind that at the time the internet was still in its infancy as a channel for distribution of works. The transformative and creative uses of works by internet users would eventually thrive, but by that time it was only nascent. Uses of works on the internet, even for legitimate purposes, were considered open doors to uncontrolled circulation of works and piracy.
So that was the so-called golden age of internet, when everyone could upload, re-upload, give information. We all remember this dial-in function of the internet. But what happened next? What happened with this harmonization? And how
Yeah,
you
it
reached
was,
this?
as you said, the golden time, but unfortunately, this harmonization objective largely failed due to the unexpected turnout of the internet. I guess no one was expecting back in 2001 that the internet would be what it is today. So the CDSM directive now assumes that copyright exceptions should become enabling devices and not constraints imposed on valuable uses such as education, access and preservation of culture and information, scientific research, or other socially positive interests, which should be enhanced in order to develop an information society for all. In other words, the exception is not just a derogation to the rule, it becomes a rule of its own to pursue certain objectives that prevail over the protection of authors and copyright owners. So I would like to present some of the exceptions, actually each of the exceptions. And first one is text and data mining, the so-called TDM. So TDM consists of automatized and electronic analysis of large amounts of data in order to extract information and patterns that cannot be processed or detected by human reading. Such data processing and knowledge management tools are now pervasive in many fields, from scientific research, pharmaceutical and medical domains, to journalism, information research and processing, so as to satisfy the requests of consumers and internet users. Artificial intelligence based on machine learning is also deeply reliant on data mining and analyzing. The second exception is actually online education. So the fundamental objective of Article 5 of the directive is to improve the situation of teaching establishments by obliging member states to allow for digital uses of copyrighted works and other subject matters for the purpose of illustration for teaching. The purpose of the new exception is to authorize the online use of works for illustration and teaching. So here it is important to be noted that the use must take place under the responsibility of an educational establishment on its premises and or other venues, or through a secure electronic environment accessible only by the educational establishment's pupils or students and teaching staff. Also, the most controversial aspect of Article 5 is its interface with licensing. The exception is said to be unwaivable by contract, yet Article 5, paragraph 2 preserves the possibility for member states to authorize right holders to allow for digital educational uses through a licensing system, either in whole or for some types of works or subject matters, such as works intended for educational market or sheet music, etc. The third exception is the different uses by cultural heritage institutions, the so-called CHIs. So the notion of a CHI is essential throughout the directive, and it is defined by Article 2, paragraph 3 as a publicly accessible library or museum, an archive, or a film or audio heritage institution. So it could also cover libraries of educational or research establishments and of public sector broadcasting organization. So this vast notion is likely to encompass a great number of institutions on conditions they are open to the public, as libraries and museums. Conversely, archives or film institutions would be included in that definition irrespectively of their public accessibility, which makes sense as this is not usually their primary mandate. Also, Article 6 of the directive requires member states to authorize CHIs to make copies of works in their collection for the purposes of preservation. This provision aims at remedying the current situation where a non-mandatory and narrow exception only admits specific acts of reproductions with no explicit purpose, which does not allow acts of digitalization of an entire collection. And the fourth exception is the protection of public domains. It should be noted that Article 14 of the directive was a last-minute addition, but it is significant and unprecedented. Hence, its purpose is to prevent reproduction of public domain works from being vested with a regained exclusive exclusive protection in the form of a copyright or any related rights in the reproduction itself. It should be noted that this is a regular practice in museums where photographs of works in their collections are accompanied by a copyright notice requiring authorization or license from the museum itself before any use. Such a copyright claim is usually illegitimate, and it's a limit for the public access to artworks and other copyrighted content. It is illegitimate because the photograph tends to be faithful reproduction of the painting with no creative choices that could establish some originality in it. But still, in some member states, a related right or even a special copyright on photographs, which does not require originality, proffers some ground for a renewed exclusive right. The Wikimedia Foundation, actually, which is a public domain, has been condemned in Germany for their use of images of paintings in the public domain, and the copyright of the museums in those photographs was confirmed.
So to sum up, the exceptions were about text and data mining, online education, uses by cultural heritage institutions, and protection of public domain works.
Yes.
We could go into details more about, and if there are some questions about any of it, please ask them in the chat. But let's go forward to how does the directive enhances the access to content?
Well, that's the second main purpose of the directive, and is looked in the third title of the document. The CDSM directive actually endeavors to better organize the digital exploitation and making available of works, thereby fostering a genuine digital single market. We should start with what were the obstacles that we had by now. And the first one is legal and results from the essential rule of territoriality in copyright. According to the territorial nature of copyright, like any other IP right, the exploitation of a copyrighted work has to be authorized by its holder for each member state where it is exploited. A second hurdle lies in the overall complexity of clearing copyright in some works, either due to the multiplicity of right holders, such as in movies, or to their absence or inaction with the unexpected outcome that works are not included in offers of valuable content, to the detriment of exploiters, right holders, and the publics alike. So the first way of enhancing the access to content is the attenuation of territoriality. Different rules mitigating the principle of territoriality are scattered through the directive.
I believe there are many rules. Sorry to interrupt you, Sveti. Could you please point us towards some example? How does this work?
Well, maybe you should think about Spotify. So you have a profile, you pay some amount in order for you to listen to music, to stream it all the time, no commercials and stuff like that. And then you go on a vacation, for example, in Spain, and all of a sudden you don't have access to like half of the songs you usually listen to because for example, Spotify managed to license all the rights for Bulgaria, but couldn't do so for Spain. Now what the directive tries to accomplish is that the rule is since the user has paid the owed money for the usage of any copyrighted works, they should have access to them in the whole European Union, regardless of their exact location in some member state or another one.
Great.
So is that clear enough?
Thank you. Yes.
By defeating complex determination of the territory in which the use should be authorized by license or by an exception, such unique localization better secures the uses promoted by the EU legislator. The challenge of territoriality, however, still stands firm in copyright law, and the CDSM directive has only addressed it on the margins, if one could say so. The second way of enhancing access to content having legal devices facilitating the making available of works. So beyond the territorial fragmentation of copyright rules, potential users of creative content need to navigate the maze of copyright clearance, where authorizations from different right holders for different rights need to be ascertained. The complexity of such a task largely results in a poor development of lawful online services, providing works such as music, films, or TV programs. So a few provisions in the CDSM directive address this issue, albeit in a piecemeal and timed manner, although not in the needed depth. So if I can point out one, this is the collective licensing scheme, which idea is to, when you want to have a license, for example, for some movies, for example, 5 movies, you go in the particular country and you find a collective management organization. You make contract with them, and it's their responsibility from there on to find all the right holders and to pay them remuneration for the use of their copyrighted works. So here it is important also to say that this will cover also the authors who are not members of the collective management organization. And since they are not members, the directive have a right for them to opt out of such contracts. So if they don't want their works to be used, they need to specifically opt out. If they don't specifically opt out, their work can be used based on the contract with the collective licensing organization.
Right.
So the next thing that the directive tries to accomplish is a fairer marketplace. And the directive purports to redress some unfairness or perceived as such in the digital market environment, generally included by the strong economic positions of some actors. So the first one is, as Ioana mentioned earlier, the IP right for press publishers. The enactment of a new neighboring right in favor of press publishers was one of the most contentious points of the directive. It was triggered by the long dispute between the press publishers and news aggregators such as Google News, the latter being accused of exploiting the value of press publications without compensating the publishers.
So we could speak about those are the pop-ups that come up when you Google something, the pop-up bubbles that you can read more about. You click.
Yes, and without going to the page itself.
But you don't go to the page of the redactor in the new. So this would probably be limited by the new.
I think we have some kind of an issue, but yeah.
Okay. Yeah. Move.
The main thing is that actually there is no users flow generated to the original page, if you can say so. So confronted with their rapid decline in the digital age and with the competition from search engines providing snippets from media websites, press publishers have increasingly claimed that only such a specific right would help them defeat the US giant by strengthening their negotiating power. Examples could be daily newspapers, weekly or monthly magazines, and news websites, including mostly literary works, but also photographs and videos. It should be noted that the line between press publications and audiovisual media might be difficult to draw in some cases. Periodicals that are published for scientific or academic purposes, such as scientific journals, are explicitly excluded, as well as websites and blogs that provide information as part of an activity that is not carried out under the initiative, editorial responsibility, and control of a news publisher.
So are there any limitations that press publishers should be aware of?
Yes, of course. Compared to copyright or other related rights of the acquires, the new right is limited in several respects. It only applies to online uses of press publications. So reprinting or any other form of non-digital reproduction of a press article would still be authorized. It does not extend to private or non-commercial uses by individual users. Here it should be noted that the restriction is quite narrow. Non-commercial use of press publications by non-for-profit association or other non-individual actors would be infringed of the new right. Also, the next limitation is that the right does not apply in respect of the use of mere facts, individual words, or very short extracts of a press publication. The notion of a short extract is not very well clarified in the directive. And the final limitation is the duration of the right, which is only 2 years after the date of the publication, thus making it the shortest right in the intellectual property bundle. So Article 15, paragraph 2, of the CDSM directive addresses the possible overlap of the new right with copyright, which would generally also continue to exist in the press publications. The general principle is that the press publisher's rights shall in no way affect any copyright. Therefore, that right should not be invoked against authors nor deprive them of the exploitation of their copyright. Freedom that users enjoy from copyright exception or expiration should not be impeded by the exercise of the publisher's right either. So all things considered, the many limitations and the uncertainties that this new right contains make its efficiency quite doubtful, but we'll live and we'll see, as people say. The next thing that is like very interesting and important of the CDSM directive is actually the Article 17, the master provision of the directive. As we already told you, it's a page and a half. It's during the whole process of adoption of the directive, this was the focus of all attention. The provision everybody was talking about, even far beyond the EU copyright circles. Article 17 applies to online content sharing service providers who are defined as a provider of an information society service of which the main or one of the main purposes is to store and give the public access to a large amount of copyright protected works or other protected subject matter uploaded by its users, which it organizes and promotes for profit-making purposes. So to qualify as such platform, the provider meets two conditions. Firstly, the main purpose of the service is to give the public access to a large amount of works uploaded by users. And secondly, the content offered to the public are organized and promoted for profit-making purposes.
So I will speak about the elephant in the room. We're going towards YouTube, right? This directive is focused on this part of the directive about YouTube.
Yes, exactly. It's actually especially for YouTube. all of this in Article 17. Since YouTube is the biggest and one of the only ones, I think, such platforms in the world, it's a way to, since most of the YouTube is responsible for the bigger portion of copyright streaming in the internet, as opposite to the really smaller portion of licensing remuneration paid to authors. So platforms such as Spotify and Netflix pay maybe around 70%. Don't keep me on the numbers.
Yeah, absolutely.
But maybe around 70% of all remuneration paid to authors against like 20% to YouTube. And as a comparison, I think the statistic is that maybe around 70% of all the music streamed through the internet is by using YouTube. So you can see why is this so important. So the requirement of Article 17 of giving the public access to the definition of a platform makes it so that, by my opinion, in my view, the directive excludes Facebook, Instagram, and other social media networks where works can be uploaded by users, but not further organized or promoted by the network itself, and that do not compete in any way with the streaming services. So here it should be noted that in order to avoid liability, video sharing platforms such as YouTube need to demonstrate that they have complied with 3 cumulative obligations. They have made best efforts to obtain authorization for the usage of copyright. They have made, in accordance with high industry standards of professional diligence, best efforts to ensure the unavailability of specific works and other subject matter for which the right holders have provided the service providers with the relevant and necessary information. They have acted expeditiously upon receiving a sufficiently substantiated notice from the right holders to disable access to or to remove from their websites the notified works or other subject matters, and made best efforts to prevent their future uploads. So choosing between requests from copyright owners and the accessory sanction of liability and the demands of users for leaving their content visible on the platform, in my opinion, is not a balanced decision. Such concerns about the impact on freedom of speech are genuine and have been largely voiced despite the many but clumsy safeguards that the rest of the article provides and that we will address later. It also led the Polish government, as Joanna said earlier, to file an action for annulment of this provision due to its potential impact on freedom of expression. The action of the Republic of Poland is based on an alleged breach of the right to freedom of expression and information as inter alia guaranteed by Article 11 of the EU Chapter of Fundamental Rights. Poland claimed that in practice, in order to comply with these best efforts obligations, the platforms must carry out preventative monitoring of all the content that their users wish to upload by applying automatic recognition and filtering tools. This, it said, creates a risk that lawful content could be blocked automatically by algorithms even before it is made available online. Anyway, the Court of Justice of the European Union didn't found the claim to be enough argumented in order to accept it, and they declined the claim. Many important takeaways were made in that decision, but the most important one is that the CJEU confirmed that Article 17 is new and specific liability regime that is applicable to online platforms, and they should apply it in their everyday activity. So
thank you, Sid, for that part. Could I move you forward to we did use fair earlier. We said about fair market. Could you tell me more about that? What new fair rights can publishers of content have?
Yes, of course. The first right that is important for us to discuss here is the right to fair remuneration. Article 18 of the adopted directive provides that the member states shall ensure that where authors and performers license or transfer their exclusive rights for the exploitation of their works or other subject matter, they're entitled to receive appropriate and proportionate remuneration. Appropriate and proportionate is said to refer to the actual or potential economic value of the license and transferred rights. If we can put it in a short summary, if one author sold his right for the amount of one, and the buyer made profit 100, then the author has the right to go and ask the buyer of the license to give them a remuneration that is proportionate to the profit they made from the copyrighted work.
Of course, the other thing is the usage, because it is not, it is it is important how long this actually
works
creation.
will-
Yes.
Yeah, because that's the other very
Mm.
important part of the directive. Article 22 of the directive grants authors and performers a right to revoke a contract transferring or licensing their rights if there is a lack of exploitation of the work or performance. So if someone had license, if they had given a license to someone and this person doesn't use in any way the copyrighted work, the author has the right to revoke the contract and find someone else to whom to give license to.
Great. Well, we might see the story of David and Goliath here. We're seeing. We will have a quick change in our schedule, but firstly, I want to ask you one of the questions that we received about the directive. Please, whoever from you decides to answer it, are the rules of the directives enforceable and how?
Yes, they are enforceable. So as Ioana mentioned earlier, the deadline for the national transposition of the directive was 7th of June 2021. So it should be noted that after this date, the directive has a direct application in the member states in which no measures were taken regarding the transposition of the directive. So maybe here it would be interesting for our public to say that by this date, 7th of June 2021, the countries that haven't yet taken any measures to implement the directive were Bulgaria, of course, Cyprus, Denmark, Greece, France, Latvia, Poland, Portugal, etc. There were many. Currently, the countries that still haven't taken any measures in implementing the directive are Bulgaria, Greece, Latvia, Portugal, Finland, and Sweden. So in these member states, the directive has direct application. So it's living legislation that has to be applied in everyday activity. Here in Bulgaria, we don't have local legislation, so we should use the directive for the foreseeable future. Yeah.
Great. Thank you, Tsveti, for that overview. We have one or two questions ahead, but as Ms. Genevieve Petrova is already with us, and we will invite her for a quick discussion about her experience navigating in the digital EU market. I'll make just a few words that Ms. Petrova is co-founder of Remix Global, one of the most successful e-commerce businesses in the European Union. They work with Gushev & Partners from the beginning, and we are happy to see that they were successfully able to sell their business to American trade-up company. But that is not the end of the road for Ms. Petrova. So I will pass the word towards you. Could you please give us a quick overview of your road until now with Remix and other businesses behind?
Hi, everyone, and thank you for the invitation. I was actually invited not just because I've been working with Gugushef & Partners for many years, including in the area of copyright and everything related to EU regulations for our online business, but also because I've been working in IT and online for many years, let me not say more than 20 now, the past 10 of which I've been executive director of Remix, which is the company owning remixshop.com. It's one of the big sustainable fashion websites, online shops in Europe, mostly in Central and Eastern Europe. The website sells in 8 markets now, but it started about 10 years ago as a typical garage business in Bulgaria. Me and 3 other partners, we launched the website and we launched the light processing where we were recycling clothes that were no longer used by other people. With the time, we started selling outlet and old collections as well, mostly focused on fashion, but also selling some home items. And eventually the business grew to encompass 8 markets, including Germany, Austria, Poland, Czech Republic, Slovakia, Hungary, Bulgaria, Romania, and Greece. So I've lived through many changes of the website, of the online shop. I've lived through different regulations, including everyone's favorite GDPR, which affected us a lot because we had over 1 million registered users. So we were definitely falling under the regulations of GDPR. And we worked with Joanna about half a year to 1 year to prepare for that until it comes into force. Basically, that's the story of Remix. We grew from Bulgaria, expanding to Greece, Romania, and other Central and Eastern European countries. And I can proudly say that the business grew to be one of the major players in the sustainable fashion industry in Europe until we sold it last year to the American leader in the industry. And eventually, I no longer had an engagement to work for the new owners. So I'm starting new ventures, some of which will be online again. So I'm interested in the new regulations and I'm following it. I hope it won't be applied soon in Bulgaria because it's a lot of complication. But I understand the grounds for it. So you asked me when we were talking about what I'm going to share today, you asked me to share my experience in how we tackle the changes in the legal framework that affects digital businesses. And to be honest, once the business grew bigger, we had an internal lawyer and we had a monthly relationship with you guys so that we can get in-time advice about what's going to come before it's too late to apply it, because sometimes we had to do software changes, not just changing texts, but changes in the way the business functions. And I remember that the previous major regulation affecting digital businesses really hit our marketing budgets because GDPR made us lose about 80% of the cookies that we had. With the time, that meant that the cheapest part of online marketing, which is remarketing, for which you need cookies, was killed. So we had to pay again for the old clients, targeting them as though they were new clients, so that we can attract them and remind them about ourselves again and again. And what this ended up with is that we actually invested more marketing money for the same clients, for the same amount of orders. And the online advertisers such as Google and Facebook profited from that because usually remarketing is much cheaper than initial targeting of clients. So that was not really fair. And I'm saying this to underline that sometimes when lawmakers introduce new directives, they should better consult with operating businesses and see it from the business's perspective, because the goal, I admit, was not to damage the budgets of businesses which are much smaller than Google and Facebook, like Remix, for example, but the end effect was such. I understand that keeping the privacy and copyright of authors is a priority for the European Union, and it should be. It's fair. It's a fair approach, and that's how it should be. But the way in which we should reach that goal should be very well thought over. That's the difficult part that we've been through, but we've tried to make the changes in advance before the regulations come into force. Just because everybody in the online sector in the countries where we operate was very scared last time when this regulation entered into force, GDPR. So I'm comparing this one to GDPR because it's a big new change, a lot of technical and marketing efforts that have to be made from the online shops and the digital businesses. But I think that this one will especially affect online platforms, as you mentioned, YouTube and other streaming platforms and all the platforms which will show content the copyright over which is not 100% clear. And it will limit their scope, it will limit their income, and it will potentially lead to some penalties for them. But my advice from experience would be to always expect in advance and to always hire a legal team to work on it in advance. And another very useful thing is that we've always had an internal person responsible for the project in the company. We were not just counting on the fact that Gugushev and Partners will do everything that needs to be done related to the new regulation, because they don't know every inside detail of the business. So we would always have a responsible person for the project from Remix to work with Gugushev and Partners when implementing something new, be it another method of payment, entering another market and changing general conditions, implementing a new directive like the one you were discussing today. So that's in a nutshell about Remix and myself.
Great. So be prepared and know what's ahead. I would like to ask you one more question. What do you think as an entrepreneur by soul? What do you think is the right attitude the new entrepreneur in today's time should be prepared if he wants to grow into the EU digital landscape?
Well, the attitude is to start thinking about legal and accounting advice much earlier than before, because 10, 20 years back, you could make mistakes and the institutions would not notice for a long time. Right now, there's a good chance that you wouldn't be fined as well, but there are much more regulations, and there are many more institutions created even in less organized markets like Bulgaria to follow about what's happening. I've been responsible for marketing and customer service and IT in Remix, and I have been dealing with the Commission for Protection of the Consumers on a weekly basis, literally, the last 3-4 years. If I compare it to 10 years back, we've probably received one request for a year. And also the intra-European communication in these institutions is working well, in my opinion, because we've been receiving a lot of requests. They were not always complaints. Sometimes they were just requests from users, from clients from other countries, and they were redirecting it automatically to the Bulgarian institution. So at one point, we started working with one centralized point of contact for anything we need to consider in terms of our clients, or in terms of brands, for example, because we've been working with brands, and sometimes we would receive a request where we would have to prove that we have the right to sell that brand in that territory. And these would start coming more and more through the centralized intra-country European network for protection of consumers, which was not the case before. So my advice to entrepreneurs would be that they shouldn't be that reckless and that much free-spirited like they could have been 20 years ago, because right now there are more regulations. The EU is the leader in regulating privacy and copyright in the world, and I think everyone follows. But my personal opinion is that Google does have a right, or Alphabet does have a point in disliking the new regulation, because it's been for me, it's something that comes out of the blue. And I think that every time when there is something that would change the way that businesses work, it should be more gradual, it should be more thought over, it should be a step-by-step process, not just, boof, this is the new regulation, you have to implement it in all those countries, because after all, the businesses are the ones that provide the food for the government. The government should work for the businesses and not the other way around.
I see. Well, I know you're very busy, so I'll just allow myself one more question that I received. Should Bulgaria be the gateway to European Union as an online business? Why did you choose Bulgarian? Will you continue to do so in the future?
I'm planning to do so, yeah. Well, we chose Bulgaria with my partners because most of us, although we've been living in other places in Europe and outside of Europe, we came back here, and it was a point in time when we were all together. But apart from that, we chose to build our warehouse, processing, and HQ in Bulgaria because it's a good place for doing business for many reasons. And actually, a proof of my opinion is the fact that the new owner, which is a NASDAQ listed public company in the States, they chose to continue their expansion in Central and Western Europe from Bulgaria as well. Just a few months ago, they launched one of the biggest warehouses and processing facilities in Bulgaria. And the reasons are multiple, among which is the still lower cost of labor, which is quality versus price is very good in Bulgaria. Also, the fact that geographically Bulgaria is very well connected in terms of logistics. For example, we were delivering in Germany 2 days after the order. One day was just our decision to slow it down one day in order to optimize transport to Germany. Last but not least, taxes are 10% flat, as everybody knows in Bulgaria, which is a big benefit for all businesses. So we chose to be here and to sell in all other countries in Europe from here. And this will continue with Remix and with my other next ventures as well.
Great. Thank you very much. I believe you said that 2 is your top time in order for you to give us, if you can give us a quick sneak peek about your new projects ahead, or we should be waiting.
I don't think, yeah, not yet. I do have more time. It's still okay. So if ever anyone has a few quick questions, I'm available.
Well, I will see to it that if there is anything coming in the chat. Well, I believe people have seen and heard your story. We have most of our audience here is from Bulgaria, so they do hear you loud and clear. If something I could end this conversation with, what do you believe? How were you able to always go around different bottlenecks concerning legal? You said about you have your internal counsel, you said about externally helping, but as a mindset, was there something that you should always be prepared, or were you planning ahead of time? Were you able to follow any guidelines from European Union? What was the process for you to be prepared at all times?
We were not always prepared. We started being prepared with the time when we were big enough to be able to afford having enough people being responsible for all the projects. But our strategy was as I mentioned earlier, to always have people from Gugushev working on different subjects. We had one person working with us on employment, one working with us on contracts, be it trade contracts or insurance contracts or other, and one person working on the content, which is copyright and privacy. So we would always have different people on your side responsible for the different topics where our business was involved. And another thing is that I think at least one of the managers in the company should have at least a general knowledge of the legal framework in Bulgaria and in the EU, just to know what to ask the lawyers. When absolutely no one from the management has any idea of how things work from the legal perspective, it's a bit risky or expensive because they have to hire for much higher engagement per month.
Thank you very much. Thank you for your time. Because we have one more roof legislation to go through, I would like to move forward with the webinar. Thank you for your time. If you're able to stay with us, we will gladly appreciate it. If some more questions come in our way, we will do our best to focus them towards you.
Okay, I hope it was interesting for the others, and I wish you a nice rest of the seminar.
Thank you
so much.
Thank you.
You're welcome.
Well,
Bye.
the next important topic of today is Regulation 1150 from 2019 about the e-commerce businesses and online shops. Wow, just the perfect time to continue. Ioana, could you please give us a brief overview?
Yes, of course, Stefan, thank you. Since the past decades, digital platforms have become essential intermediaries in the daily lives of individual consumers and small businesses. All these relationships must be regulated, as digital platforms actually have become super dominant, and European legislation should take measures against such anti-competitive behavior in order to protect small business counterparts. Actually, the aim of this new, it is not new, but the changes in this regulation is to expand existing transparency duties of the digital platforms and promoting fairness and transparency for business users of online intermediation services. Here, the point is over the business, the small businesses, because digital platforms could simply manipulate the algorithm managing and enhancing their own products. So the P2B regulation became directly applicable in the European Union. Anyway, there are some important developments for online intermediation services in the context of e-commerce platforms. So Sveti will be in more details of what exactly they are. Sveti, please.
Thank you so much. Before we jump into the sanctions regime and go on with Genoveva's team of, thinking about the whole EU legislation, I would like to start with a brief reminder of the main aspects of this regulation. So the platform to business or P2B regulation applies to providers of online search engines and online intermediation services. So while the concept of online search engine is familiar, online intermediation services are a new and potentially far-reaching concept in the context of the EU legislation. The P2B regulation defines online intermediation services as any service that is normally provided for remuneration at a distance by electronic means and at the individual request of a recipient of a service, for example, any information society service provider. Also, it allows business users to offer goods or services to consumers that facilitate the initiation of direct transactions between those business users and consumers. It's irrespective of how the transactions are ultimately concluded, offline or online. And the third condition is it is provided to business users on the basis of contractual relationship between the provider of the service and the business users that offer goods or services to the consumers. So the P2B regulation expressly confirms that e-commerce marketplace, price comparison tools, app stores, and social media are within its scope, and it does not apply to peer-to-peer online intermediation services where no business users are present, pure business-to-business online intermediation services that are not offered to consumers, online payment services, online advertising tools, or online advertising exchanges. Notably, whether the transaction, as I said earlier, between business and users and consumers involve any monetary payment or are partially concluded offline is not relevant to the application of the P2B regulation. So the regulation calls a business user a person who any private individual actually that is acting in a commercial or professional capacity, or any legal person which through online intermediation services, e-commerce platforms, offers goods or services to consumers for purposes relating to its trade, business, craft, or profession. Here, it's a good place to make a comparison between the business user and the average consumer. So since the average consumer theory is more known and famous already in the European Union, so we perceive the average consumer as someone who doesn't form their own opinion independent. They're very reliant on what it's written on a site, what it's written in a commercial. Everything should be in front of their eyes on the screen, nothing hidden. So here, the principle is pretty much the same. The business user is perceived as an average consumer, if one may say so. So the main obligations of the P2B regulations is the purpose is to avoid situations where the business user may be negatively affected by decisions of the platform and establish the principles by which platforms can treat them. This way, the imbalance of powers between the relevant business user and the platform is somehow regulated, so the business user has certain rights. So in order to meet this purpose, this objective, and to prevent unfair situations, the P2B regulation imposes a series of measures. So the whole idea of the regulation is that, all the business and personal relationships are formed on the basis of bargaining between the parties. So they bargain until they find conditions on which both parties agree to and consider these conditions fair and profitable for both parties. Since not only the digital economic, but the whole economic has expanded, and there is, for example, for one business, there is one contract that is typical for all the relationships with all the third parties. The general terms and conditions entered into the everyday business, and so these terms and conditions actually make the bargaining part of entering into a contractual relationship pretty hard to happen. So it's very common for one of the parties to actually not consider the conditions fair and to haven't managed to bargain any conditions. And this is the idea of the P2B regulation. It's to make the parties in the relationship more equal than they are now. So, and the P2B regulations try to accomplish this through a series of measures, all of them under the theme of transparency in the relationship, transparency in the general conditions for business users. So any vague, confusing, or unclear terms are prohibited. Always the reasons for suspending, terminating, or restricting users' account should be as clear as possible, stated prior to the action taken, etc. Also, the general conditions can only be changed with a minimum of 15 days notice to the business users, and they have the right to stop using the service during this period and not suffer any consequences of that if they do not agree with the change. Also, online intermediation service provider platforms should ensure that the identity of the business user is always clear and visible on the platform itself. The purpose of this is to make sure that if the business user is not happy with the relationship they have with the platform, for them to be able to change the platform, to change the service provider, and still be noticed and renew. The client to have the knowledge for the exact provider that they have a contract with, and not the intermediation platform that the provider of the service uses. If that is clear enough, Stefan.
Yeah, for transparency, absolutely. What other series of measures are there?
As I said, the rules regarding the suspension, restriction, or termination of accounts. So it is necessary for the platform to inform the business user affected by any of these situations about the reasons for this. In addition, the business user must be given the opportunity to clarify the facts that have led to the suspension, restriction, or termination of the service provided. If the suspension has been originated by a notification from a third party, the content of this notification should be provided to the affected business user. Also,
Sorry, because until now it was one-sided. Everyone could lose their businesses in one of those platforms from day to day, and this provides them some protection to be still there and to have some clarification what is happening, and even to have an opportunity to appeal it. Is that right? Appeal that decision.
They can also appeal. So those platforms have the obligation to have
Mediators.
mediators.
Yes,
Thank you.
mediators.
To have the mediators appointed in order for them to give the opportunity to the business users to, if they do not agree, to go through mediation first, and if that doesn't work, to use the court as an end option to have the dispute resolved. So in Bulgaria, the way the e-commerce law is written, all the platforms are obliged to find those two mediators and to give their names in the terms and conditions in order for the business users to know who they can contact in such a case. It should also be noted that the mediation stage isn't the business user can skip through it and go directly to the court. So it's not obligatory for him to go through mediation, but it's a good option.
I see.
Also, maybe we could talk about the special obligation regarding the search engines. So the principle of the previously described measures apply to some search engines, although in a different way, since the users of search engines do not necessarily have a contractual relationship with them. Obligations relevant to search engines include content ranking. So the parameters that are most significant in determining the ranking and the relative importance of each parameter must be set out. They must be public and easily accessible, drafted in a simple and understandable manner. So here maybe it should be noted that the same apply to the intermediation platforms. So there will be no more the algorithm religion where you don't actually know how things work and you have something like a religion to it and you're scared of the algorithm. So from now on, all these platforms, all these online search engines will be obliged to give some criteria based on which the algorithm gives you a better positioning.
So they will give you a look behind the curtains, but they won't take your hand to bring you there. So it will be just
after all, it's a business secret. So it wouldn't be a good idea to give it all away.
But it's pretty interesting because one of the biggest ideas in businesses and consulting concerns this working with the algorithm, and in the future they will have to disclose some of this information.
Yeah, new regulation is baking in that direction.
Great.
Maybe a subject to another webinar.
Oh, that would be great. So for the next steps, are there any guidelines that we should know currently about the P2B regulation?
Well, the European Commission issued guidelines on the application of the regulation. They were issued on the 7th of December 2020 and are in regards to the ranking. So the providers should implement a user-oriented approach by giving a meaningful explanation of their ranking mechanisms and the main parameters used in plain and intelligible language without overwhelming users with lengthy or complex descriptions. For the explanation to be meaningful, providers should take account of the nature, technical ability, and needs of the average users of given service. Also, each provider should conduct an individual assessment to determine what measures they need to take to comply with the ranking obligations, which are in Article 5 of the regulation. This individual assessment must be conducted in a technologically neutral manner, in the sense that the particular technology used as part of the ranking process is not decisive, if one may say so. I can say that the guidelines, though soft law, are very helpful in applying any new regulations. So once there are guidelines issued from the Commission, it's very helpful for all the colleagues or for all the business around to read through them and see if they can be helpful for their particular situation.
Thank you, Svetlana, for this overview. We were even faster in the regulation, but it's much more clear. Please, for all the audience, don't hesitate to ask any questions in the chat. I currently have one for the regulations, regulation 1150, which is what would be the next steps in the application of the regulation?
Well, if I may answer, in view of all that we've discussed so far, it seems clear that the regulation is a clear reflection of the efforts that the European Union is making to regulate what has come to be known as the online platform economy, and therefore it should be taken into account by all the players involved in it, and in particular by the providers of online intermediation services and search engines. It should be also noted that by now all intermediation services platforms should have already implemented Regulation 2019-1150. If not, we strongly recommend taking actions on it, starting by amending the conditions of the platform according to the requirements of the P2B regulation. However, this may not be an easy task, as everyone knows. So to accomplish it, legal assistance may be required and actually strongly recommended.
Great. I just give heads up to the audience that I have one more question. You have some time. If you want to ask something, don't hesitate. So the other question that I do have is, could we mention some exact platforms which are by definition the intermediate service provider? So
well, if we talk worldwide, we could say eBay, Amazon. Locally here in Bulgaria, we have OLX, we have EMAC, also one of our clients, NextBasket. They also provide platforms for business users to trade and have online shops.
I see. Thank you. Thank you, Sveti. Thank you, Anna. Again, I'll give just 2 more minutes if any other question come. And I want to, during that time, do a quick thank you towards the team of Legal 500 and Chris. Thank you for having us and giving us this opportunity to be able to provide this information towards broader audience that we have. And I hope that whatever we have spoken today, as Genoveva said earlier, you will be better prepared for the future, for the changes that come in the EU digital landscape. So, Chris, what would you think about our today webinar?
Very good, thank you. Very informative, and I'd like to say thank you on behalf of Legal 500 to Gugushev and Partners Law Office for partnering with us to bring this fascinating webinar together. I would also like to extend a thank you to your speakers for the valuable insight, and I'd like to say a thank you to those of you around the world who are able to join us for this webinar.
Thank you to Chris.
Amazing, thank you. So, again, to wrap up, I would like to give the word to Ioana to give us some sum up of what we spoke today, and after that, please, could we close the webinar?
Thank you very much, Stefan. First of all, I would like to thank to Sveti and to you for your brilliant presentation and moderation, and for the amount of hard work you actually have done. I think that the main idea of these webinars is to simplify and explain rather complex legal issues to our clients in order for them to start a new business or to continue their business and their current activities according to the new regulations. In the area of IP rights, technology is playing an increasing role. This is sure in conducting our work, and to an extent replacing whole segments of it. So in summary of my colleagues' brilliant presentations, I would like to take the opportunity to provide a glimpse, if I may say, of the future. And this is the artificial intelligence of the IP rights. Artificial intelligence has undergone unprecedented development in the recent years and will most likely have a defining role in the future of our society. So the legal implications generated by the technological evolution in the field of the artificial intelligence are extremely diverse. For example, and just to provide a glimpse, the algorithms of which Sveti spoke earlier are not protected by copyright as copyrights. And actually, they must be protected somehow, like something. So maybe the next steps are to think about how these algorithms will be protected as some kind of copyrights or some kind of patents, because it is possible to have such kind of protection. But of course, the new legislation must regulate this, because now we have only a kind of protection for them as a know-how and trade secrets.
Yes, not as a copyright.
Yes, but actually they are kind of copyrights, by my opinion, my personal opinion. So now we have, if I may say so, now we have just the protection of the computer program, of the software,
Of the
by
code,
by the code, yes, not by the algorithm. But sometimes the algorithm is the substantial part. It's a substantial part of the whole product, not only the code. So the artificial intelligence, the algorithms, and this kind of legislation, which actually will come.
And we'll see what will happen.
Yes, but I suppose that here we have some business people attending, and they know that time is gold. So I will finish our webinar until here, and after that, we are ready to speak about the artificial intelligence and the new tendencies in this kind of
legislation.
Yes. Thank you.
So-
Thank you very much.
Thank you. So stay tuned for more AI, the next topic. Thank you very much for the webinar. Thank you, Chris. Thanks for the audience that sticks with us to the end.
Thank you.